Thank you. It's a great pleasure and privilege to be here. I'm Ralph Wilde. I'm Professor of International Law at University College London, and an area of my academic work is the subject of Palestine and international law, on which I published in the Palestine Yearbook of International Law and the Journal of the History of International Law. Some time ago, I served as legal advisor to the EU and DFID-funded expert body to the PLO peace negotiators on internationalization and trusteeship being considered then for a peace agreement, based on my book on those practices implemented in other places in the world. I later worked as a legal advisor to the Palestinian human rights NGOs Al-Haq Palestine, Al-Haq Europe, and the Jerusalem Consortium on Human Rights. Last year, at the nomination of Al-Haq Palestine and the State of Palestine, I represented the 22 states of the League of Arab States in the advisory opinion case about the illegality of Israel's occupation of the Palestinian Gaza Strip and West Bank, including East Jerusalem, the occupied Palestinian Territory, the OPT, before the International Court of Justice, the ICJ. This year, I represented Bolivia in the current advisory opinion case before the same court on the legal rights of states and international organizations to enter and be present in the OPT to support the Palestinian people, and later served as legal counsel to Bolivia at the emergency meeting of the Hague Group of States in Bogota, Colombia. Last year, I also represented the Arab League and the Palestinian Human Rights Commission in the Palestine case before the International Criminal Court, and the Gaza-based Palestine Center for Human Rights, NGO, writing its submission included in South Africa's submission in the current genocide case against Israel before the ICJ. I speak today in an individual capacity only. In last year's advisory opinion, the ICJ adopted the position I advanced on behalf of the Arab League based on my academic publications, affirming a profound shift of approach to the situation in the OPT compared to that taken by Israel and most Western states, including the UK, aligning things with the approach taken by the State of Palestine and many states of the global majority. The court ruled that the Israeli presence in the OPT is illegal not only in its conduct, but also in its very existence. This landmark ruling was subsequently affirmed by a large majority of states in the General Assembly. As I argued and the court held, the Israeli presence in the OPT is illegal as a violation of the legal right of the self-determination of the Palestinian people and the legal prohibition on annexation of territory through the use of force. As a result, it must end as rapidly as possible. As I argued for Bolivia before the court in this year's advisory opinion, a necessary implication of the ruling that Israel's presence is illegal is that Israel lacks any entitlement to do anything in the OPT on whatever basis. In consequence, everything it does there is illegal, not just its abusive and genocidal treatment of the Palestinian people, which is also illegal as serious violations of international humanitarian law and violations of the prohibition of torture and inhuman degrading treatment, racial discrimination generally, and apartheid in particular, crimes against humanity and genocide. This also means that Israel has no legal right to decide who can enter and be present in the OPT, nor to restrict what those present can do. The fundamental character of the legal rules violated by Israel in maintaining the occupation means that all states, including the UK, bear special legal obligations to suppress these violations. These obligations are entirely separate from and more extensive than the duties that the UK and other states also have to suppress the violations of international law in Israel's abusive treatment and genocidal treatment of the Palestinian people. They are also much more fundamental and wide-ranging, since they concern the presence in the OPT in and of itself as a general matter. What I'll say about these obligations is explained in full in an expert legal opinion I wrote for the Palestinian NGO Al-Haq Europe, based on the submissions I made for the Arab League in last year's ICJ case, and the adoption of those positions by the court and endorsement by the General Assembly. The legal opinion can be found on the website of Al-Haq Europe in the Research and Publications section. Legally, all states, including the UK, must do three things. First, take all positive steps within their power to bring Israel's illegal presence in the OPT to an end. This requires full spectrum sanctions against Israel and Israeli individuals. Second, not to recognize the illegal presence as lawful. Third, not to aid or assist in maintaining the illegal presence. This is distinct from the more generally applicable, narrowly relevant rule from the international law of state responsibility, which covers violations of international law generally, where all states must not help illegality by other states when the purpose for the help is to enable that illegality. Here, the issue is different. It is more simply an obligation not to aid or assist if that would enable the illegal presence to be maintained. Whether or not the intent behind this aid or assistance is to support illegality is irrelevant. The links between the Israeli presence in the OPT on the one hand and so-called Israel proper on the other, the economy, society, military, natural resources, culture, tourism, education, etc., are multifaceted and inextricable. In consequence, it's impossible to disaggregate relations with the Israeli state and Israeli private actors to somehow identify discrete matters not linked to the presence in the OPT. Consequently, implementing the suppression obligations requires the UK and all other states to address Israel as a general matter. So with arms and intelligence sharing, the UK and other states mustn't provide any support to Israel whatsoever, not just support that might end up being used to commit serious violations of the laws of war, crimes against humanity, or genocide, since any support given is going to end up one way or another supporting the existence of the occupation. Likewise, given how the economic dimensions of the Israeli presence in the OPT are inextricably linked to the Israeli economy generally, the UK and other states must adopt a complete trade embargo against Israel as a general matter, including but not at all limited to an embargo of settlement products. Despite last year's ICJ ruling and its affirmation by the UN General Assembly, there is still a denial about, or at least a refusal to acknowledge, these fundamental legal issues on the part of many states, including the UK. Both the existential illegality of the occupation and what this means for their behavior. Even the current focus on genocide, which is, of course, vital, if conducted in isolation from the bigger picture, obscures the fact that even if Israel were not committing a genocide and other legal breaches in its conduct in the OPT, its presence would still be a breach of fundamental legal rules, and the UK and other states would still bear the fundamental legal duties to bring these breaches to an end. With the duty of non-recognition, then, what is needed is a profound shift of emphasis from non-recognition of the legality of certain conduct only, such as criticizing settlement expansion as illegal, to also non-recognition of the legality of the presence itself. This includes then a duty not to recognize as valid Israel's justifications for that presence. Obviously, annexation, but also including self-defense. Any state, including the UK, asserting that Israel has a right to be present in any or part of the OPT, including Gaza, on the basis of a right of self-defense, breaches this duty of non-recognition. The time is long overdue for all states, including the UK, to face up to the exceptional character of Israel's violations of fundamental legal obligations in maintaining its presence in the OPT, and the exceptional character of the consequential legal duty that they have to suppress this. Legally, they are not disinterested bystanders, free to pick or choose whether and to what extent they address the illegality of the presence. They are required to act, and in doing so, must be comprehensive. There's an urgent legal duty to depart from partial, selective, tokenistic, and sometimes entirely symbolic gestures and statements to concrete, effective, and comprehensive action. I'll say one final thing about the current situation in Gaza. Because Israel's presence in the OPT is in and of itself illegal, and two key consequences are, first, that Israel has no right to decide who can enter and be present there, and second, that all states, including the UK, have a duty to act to bring the violations of international law involved in Israel's presence to an end. One way that the UK and other states can discharge this duty is to seek the permission of the representatives of the Palestinian people to send a protective presence into the OPT, including but not limited to the Gaza Strip, and to escort the entry by others to provide urgent relief. So-called humanitarian intervention is intervention in a state against the wishes of the government of that state. This would not be that. Israel is not sovereign in the OPT, and its wishes are of no legal significance. If the necessary Palestinian consent were given, this would, by itself, be sufficient as a legal basis for such action. Endorsement by the United Nations General Assembly would be politically helpful, but legally unnecessary. Thank you.
Dr. Wilde, thank you so much for that